progressive or liberal, depending on your terminology. This combination is not present everywhere in the globe. So, for example, I'm just going to give 2 or 3 examples of this. For example, I currently have, this is an American, but a special American example. I currently have a PhD student who is doing a dissertation on originalism in Puerto Rico. Puerto Rico has a very progressive post-war constitution with values I think Jim would be very excited about. And conservative Puerto Rican judges have adopted living constitutionalism to undercut and undermine values that are very clearly instantiated both in broad statements and in particular provisions in the Puerto Rican Constitution. There are similar developments elsewhere. Yvonne Tu has a very interesting and important paper on originalism in the context of Malaysia and Indonesia. It's a similar constellation, progressive constitution, conservative judges. Living constitutionalism in that context operates to undermine progressive values installed in the Constitution. So our particular constellation is not the same as everywhere. It's interesting, Jim mentioned Australia, where I think that it's clear that the debate over originalism and constitutionalism, a very important part of constitutional discourse, and where the primary tendency of the Australian Constitution is one that we would characterize as originalist. Even in Canada, the home of the living tree, 2 hardcore originalists have recently been appointed as judges. So originalism, I think, is not fairly characterized as an exclusively American institution. A certain version of originalism, the version that Ken referred to, and I just want to say there are many things we could call originalism, but a particular attitude towards constitutional interpretation that's based on the almost quasi-religious view of the framing era and of the personal authorities of the framers, right? There's, in that version, it's sort of inevitably a peculiarly American phenomenon because this sort of worship of our framers obviously doesn't exist anywhere else. There's another sense in which originalism transcends national boundaries, and this has to do with the kind of originalism I do. And one of the great tragedies of the book that Jim reviewed is it leaves this part of the theory out almost entirely. So, whereas I view this as the core of the theory, and it is work that relates developments in the philosophy of language and theoretical linguistics to the interpretation of legal texts. This work is very general, right? Much of the work that I do is on constitutions, but I have a recent article that applies the same body of work to the interpretation of patent claims. That just came out, if anyone's interested in patent law, it just came out on the Yale Law Journal. And so it's very general. It can be applied to contract law, to any task of interpreting legal texts. And this, of course, is not, this kind of work is not specific to any legal culture. Right, and I just want to say that this is, Jeff Goldsworthy is a pioneer in this. There is similar work being done in Iceland, in New Zealand, really all over the world, the marriage of theories of legal interpretation to sophisticated recent work in the philosophy of language and theoretical linguistics. The third observation I'd like to make is about the originalist premise. Right, as you might imagine, as an originalist, I bristle at this characterization of originalism as making the argument for originalism axiomatic and by implication, question begging. Now, I do think it is fair to characterize some originalists as having made a move like this, right? But I do think that sophisticated academic originalism has recognized this criticism and has attempted to move beyond the criticism in a variety of ways. One possibility for misunderstanding here relates to a fundamental theoretical distinction that I've made in my work, and which not all originalists accept or understand even, really. And this is the interpretation-construction distinction. That distinction goes back in American legal theory to at least 1839, and Franz Lieber's treatise on legal hermeneutics, but it was expressed in its modern, distinctively modern form, really in the 1920s and 30s. It's strongly associated with Corbin. You find it in the great treatise writers of the first half of the 20th century, in Williston and so forth. It is a distinction between two distinct activities that form a part of what Larry Sager calls constitutional practice. I just want to say that I wholly agree that this is a key theoretical concept. And the distinction is between the activity of determining what we might call the linguistic meaning or the communicative content of a legal text, interpretation, and a second activity, the determination of the legal effect that that text will have, construction, right? That's Corbin's distinction. It's the distinction that I adopt. To the extent that originalists make a quasi-tautological move, it's about interpretation, not construction. No one can think that originalism as a practice has to be the case, right, as a matter of determining the legal effect of the constitutional text. The argument that originalists make is that some search for original meaning has to be the right theory of interpretation, of communicative content. And I won't have time to argue for originalism. I'm going to spend my whole time doing what I think is a correction of misperceptions of originalism. But that claim I will characterize as the fixation thesis, and I'll at least explain what the claim is. Okay, so what is originalism, and how does it relate to the moral readings approach that Jim Fleming and many others adhere to? There are many forms of originalism. It is correct to characterize originalism as a family of constitutional theories. But this family of constitutional theories is not all over the map, as some have argued. Instead, the family is organized around two ideas that are common to almost all originalists. There are a couple of self-identified originalists who are exceptions, but almost all the people who identify themselves as originalists affirm two ideas, and I have names for these ideas. The first idea I call the fixation thesis. The fixation thesis is the claim that the communicative content of the constitutional text is framed at the time, is fixed at the time each provision of the Constitution is framed and ratified, right? That the meaning, linguistic meaning, the communicative content, the content communicated by the text is fixed at the time each provision is framed and ratified. That is, the linguistic meaning does not change. Applications change. The legal content, the doctrine associated with the communicative content might change. But the communicative content itself does not change over time. That's true for many reasons. The classic example of this was one that Larry Tribe introduced. It's the phrase domestic violence in the American Constitution. That phrase is used to refer to internal rebellions or insurrections. They're probably race riots or slave rebellions were in the mind of the people who framed that provision. But the phrase domestic violence has an entirely different meaning today. That meaning has pretty much disappeared. We think of domestic violence as spouse abuse, abuse within a family, elder abuse, child abuse. That has nothing to do with the meaning, even though the linguistic association with the phrase has changed. If you want to know what the Constitution means, you ought to look to the way the words were used at the time the Constitution was adopted. I think that everyone ought to accept the fixation thesis, right? Everyone. Even if you reject originalism, you should accept the fixation thesis. Although it can be misunderstood, once you understand it, I think you ought to accept it. The second idea is the constraint principle. So the constraint principle is the idea, formulated abstractly, that the communicative content of the constitutional text should constrain constitutional doctrine and the decision of constitutional cases. That is, the meaning we get from interpretation ought to constrain construction. Now, the constraint principle I have formulated abstractly. I've formulated it at a level of abstraction that all originalists can agree upon it. And I'm going to talk about the variations with respect to constraint in just a moment. But the idea is that the meaning of the text, the original meaning, operates as a hard constraint. Okay. So that's what originalists can agree on. What do they disagree about? What are the variations among originalists? Well, first of all, originalists disagree about what the mechanism of fixation is. There is a predominant form of contemporary originalism, public meaning originalism. Not all contemporary originalists are public meaning originalists. Some are intentionalists. Some of the subforms of originalism are actually variations on public meaning. So, for instance, Jim referred to John McGinnis and Michael Rappaport, who have a theory that they call, I came up with this label, I kind of regret it now. They call it original methods originalism, but they believe that the original methods and the role they play is part of the public meaning. So they are public meaning originalists, right? They're debating a sub-issue about the role of legal practice at the time of the framing in determining public meaning. Contemporary intentionalists, who are serious constitutional theorists, affirm a slightly new version, new at least to the legal academy, of intentionalism. Almost all of them have adopted a neo-Gricean theory of meaning's relationship to intention. So this is the view that the meaning of a text is the meaning that the author intends to communicate to the reader based on the reader's recognition of the author's communicative intentions, right? And so this is not original intent as purposes, right? And Larry Alexander, Stephen Smith, most of the contemporary original intentions people, all of them maybe but Richard Kay, except this neo-Gricean version. Because the situation of constitutional communication is that the people who wrote the Constitution were communicating to the public, and because the authors of the Constitution had to take that into account, the current form of intentionalism converges with public meaning in all but very special cases, as the intentionalists themselves explicitly recognize and affirm. There are possible cases where there will be variations. Now, old original intent people who believe that intent is the purpose They have a completely different theory. There are reasons their theory was abandoned by originalists early on, starting in about 1984, as I myself did not recognize until decades later, right? But there are still one or two original intent originalists of that stripe. Okay, there is another form of variation, and that is originalists vary with respect to the form of the constraint principle that they affirm, right? The original meaning should constrain constitutional practice, but how constraining should it be? And here I think originalists are still working this out. I see originalism as a vibrant research program that continues to develop, right? But I'm going to give you two contrasters, two different forms of the constraint principle, a minimalist form and a maximalist form. So the minimalist form of the constraint principle, and I believe that this is the least common denominator among originalists. Everyone agrees that there's at least this much constraint, is constraint as consistency, right? So to formulate that precisely, if we were to translate the communicative content of the constitutional text into legal content, into constitutional doctrine, there must be no contradictions. Nothing that is in the legal content of constitutional doctrine may contradict the communicative content of the constitutional text, and all of the communicative content of the constitutional text must be fairly reflected in the legal content of constitutional doctrine. That's constraint as consistency. The maximalist form of constraint, I'm going to use a piece of philosophical jargon here, is constraint as supervenience. So the argument here is that the legal content of constitutional doctrine should supervene on the communicative content of the constitutional text, right? That means every little bit of constitutional doctrine must be found somewhere, derived from, in some way, the communicative content of the text. There's a technical difference between this and a different view, which would be a reductionist view, right? That just absolutely everything has to be there as opposed to be traceable there in a particular way. I'm just going to ignore the differences between those for now. I'd be happy to discuss them. Supervenience is a very strict requirement, right? And that essentially means that if you're a constraint as supervenience person, you think there's very little room for judicial creativity. I think the supervenience view is implausible. I think that it has some adherents. I don't think they fully recognize the implications of their provision. I think they will all come around in the end. I'm an optimist about theoretical debates. But at any rate, there are some people who currently affirm a supervenience view. Third area in which originalists disagree. They disagree about the extent to which the constitutional text underdetermines legal content, right? Almost all of them agree at some level that there is some zone of underdeterminacy, right? For instance, even Michael Rappaport and John McGinnis, who are just among theoreticians, the hardest of the hardcore against constitutional underdeterminacy of any kind, when you talk about the word reasonable in the Fourth Amendment, they really say, oh, well, now there it looks like there's some kind of a construction zone, right? Because it's just really, really hard to get all of the content out of the word reasonable. Reasonable looks like it's a term that is multi-criterial with incommensurable dimensions, and therefore whenever you have that, More than one thing determines whether something is reasonable. They cannot be, unless you're like a cost-benefit analysis person, they're incommensurable. That means you got to have a construction zone there. And so even they accept that, although they accept very little others under determinacy in the constitutional text. Other originalists, someone like Randy Barnett or Jack Balkin or Keith Whittington or myself, we believe that at least some provisions create substantial construction zones, right? And because they are either irreducibly ambiguous, vague, because they're multi-criterial, or maybe that's equivalent to open texture, right? Open texture is a very funny word or phrase. Or because of irreducible ambiguities, or if there are any, because of gaps in the Constitution, or contradictions, if there are any. So we believe that there are some parts of the Constitutions that create substantial construction zones, right? And then I want to say, though, that those construction zones may not have the same shape that non-originalists think. That the construction zone created by the original meaning, say of the Equal Protection Clause, may be quite different than the construction zone that would be identified if you have Dworkin's idea that the Equal Protection Clause is really the equality of persons clause, right? That may be very different than the original meaning of equal protection of the laws. But I think that there are many originalists who accept the existence of construction zones. Okay. Now, among the originalists who do accept the existence of construction zones, there are further differences, right? So Michael Paulson and Gary Lawson believe that the proper approach to construction zones is a rule of deference. I'm going to super simplify their positions, which are different, and take federalism into account, right? Just a super simplified version would be a default rule that says, when the Constitution creates an underdeterminacy, defer to the political branches, right? A Thayerian deference rule, okay. So that's one approach. That eliminates a lot of judicial discretion, right, if you take that approach. Whenever the Constitution's unclear, then defer. Jack Balkin has the method of text and principle. Now, I think Jim does not fairly characterize Jack's position. Jack's position is that the communicative content of the text, whatever it is absolutely binding on us, right? And that fidelity requires that you obey the text and not the principle for which the text was adopted. The principle can only operate within the construction zone, that is, to the extent that the text is indeterminate. Will Baude, ultimate originalism. I think Jim has very substantially mischaracterized Will's position. He's not here to defend himself. So Will's position is not that originalism is precedent and values and all those things. Will's position is that there is a lexical ordering among the modalities of constitutional interpretation, to borrow Bobbitt's phrase, or the forms of constitutional argument, to use Dick Fallon's phrase, that the meaning of the text is lexically prior to all the other modalities and constrains them. So that's very different than precedent is original meaning. That's a substantial misunderstanding of what Will's position is. I'm running out of time, but I really feel like I also need to make a side point here to talk about, I've got a clock, but I think I have only 2 minutes and 14 seconds actually on a strict clock. So Will Baude does not say that Brown and Lawrence are originalist decisions. That is not his position. His claim is that the Supreme Court has never unambiguously and decisively rejected originalism, right? And so when he talks about these decisions, he is not claiming they are originalist decisions. He is claiming that there is reasonable ground for disagreement about whether the issue in those cases could have been resolved in the way that it was on originalist grounds, right? He's making that argument for a very particular reason. If it turns out that the Supreme Court has decisively rejected originalism, then the argument that originalism is the law cannot go through. So Will's only claim is that there is room for reasonable disagreement, and the Supreme Court itself has never said, we are here rejecting the text. We are deciding this case in a way that is inconsistent with the text, right? That's the claim he makes. It's not the same as the claim that everything is originalism, or the claim that these cases, properly understood, can, in fact, at the end of the day, be seen as correctly decided on originalist grounds. Okay, in just the couple of minutes that I have remaining, let me say a little bit about Jim's version of fidelity, because this conference is about his paper, but his paper is about his book is about originalism. So how does Jim relate to originalism? And I think that the question here is not the fixation thesis. He might have views on that, I'm not sure. It's about the relationship of moral readings to the constraint principle. On my clock, I would now be out of time. So Jim, first of all, accepts a weaker role for original meaning in the enterprise. We might call this contribution, right, just to have some technical vocabulary. For Jim, the original meaning of the text, that is the communicative content of the text, fixed at the time each provision was framed and ratified, contributes to our moral reading. But it does not constrain. It does not constrain. That is, Jim believes that there are cases in which judges can properly decide in a way that is inconsistent with the original meaning of the text, not being unfaithful to what Jim sees as the big C Constitution, the small c Constitution. That is, not unfaithful to our constitutionalism, not unfaithful to our history of practices. Jim strongly believes in fidelity to the small c Constitution, but he does not believe that the big C Constitution, if understood in this originalist way as having fixed communicative content, is something that you can never override. In my terminology, he believes in a power of constructive amendment, right? Amendments that actually change legal content that would be required for consistency with the Constitution. Now those two provisions are really different. They are really and seriously different. Jim believes lots of things are okay because they are faithful to our small c Constitution, that I believe are constitutional mistakes because they are inconsistent with the communicative content of our big C Constitution, right? And so even though we have a lot in common, even though in the construction zone, I think that Jim's approach is a legitimate approach, one that has to be taken seriously. I honestly don't know what my approach is. I'm still working on this very hard problem, right? But I think his approach is one of the contenders, right? So that we have a lot of common ground, but not when it comes to consistency with the communicative content of the text. I'll stop there.
Many thanks. So you would like perhaps to come up here, or do you prefer to stay?
I think
As long as this microphone works, why don't I just sit here? Is this working fine? Yeah. Okay. Sure. Okay, well, first of all, Larry, I'm almost speechless by what you said at the beginning. And I'll have to get clarification from you about what you mean by apologizing to me for writing a book called Constitutional Originalism, a debate in which you offer a programmatic understanding of and defense of originalism as a family of theories. And I haven't heard anything that you've said today that in any way is inconsistent with what I thought you argued in that book. So I'm still kind of reeling, not having any idea what you could mean in saying you apologized to me for writing a book that I reviewed. And I tried to review it as generously as I could. I commended it for its constructive, charitable approach to articulating originalism as a programmatic undertaking, a family of theories. So I'd be interested to know what it is that you would wish to apologize for in that book. I think that my characterization of Will Bode's ultimate originalism, in the text at least, was very careful. He used formulations like, is not incompatible with originalism, or is not incompatible ultimately with originalism. He didn't say all of these decisions are correctly decided from an originalist standpoint. But he did offer a number of examples of people he identified as originalists who were making what they regarded as originalist arguments for same-sex marriage, for the Constitution prohibiting sex discrimination, for Roe versus Wade, and for Brown versus Board of Education. So I'm going to have to go back very carefully and see what it is that I said about what he wrote that is in any way a misunderstanding of what he said. Perhaps here, in speaking publicly, I made it sound more like a total concession to the critics of originalism than the book itself presents it as being. But I tried to be very careful about what he was saying and the examples that he was giving. And I simply cite the very examples that he gives of people he views as originalist making what he credits as originalist arguments for positions that traditional conventional originalists like Bork and Scalia have spent their whole lives repudiating and condemning as moral readings. Finally, I reject your characterization of my theory at the close of your paper, because I reject the idea of amending constructions. And I say in the book that I think that the fixation thesis and the constraint thesis, at least as you articulate them, maybe here's where we'll come to what you now repudiate in your earlier book. In my book, I say you yourself characterize the fixation thesis and the constraint thesis as relatively thin. I quote you as using the word thin in your book, Constitutional Originalism, a Debate. And I say in my book that indeed they're so thin that Balkin can embrace them. I said Dworkin can embrace them, and I said Barber and I certainly would embrace them. And I didn't see anything in your characterization at the end of the paper that showed why we would reject constraint. I think it must be that you think somehow that what we say is that the original public meaning is quite abstract. So it constrains in the way that abstract commitments constrain. And I never say, well, we're going to override the constraint of those abstract commitments in the name of something else. I think Dworkin, Barbara, and I would always say that we're giving the best understanding of those abstract commitments. We're not overriding the original meaning of those abstract commitments. And I think Balkin would say something very similar to that. I think what happened in your attempt to understand my position was because when I talked about fit and justification, and I argued that we don't have an obligation to follow the past as such, I was trying to come up with a vocabulary for, well, what hold does original public meaning, what hold do precedents have on us? And so on the one hand, you got obligation. On the other hand, you got, well, it's merely a starting point. I simply adopted Jack Balkin's language about the hold that history has on us. I said, it's a factor, it's a resource, and I believe I said, but it's not a constraint. And you seem to pick up on that. But I was quoting Jack Balkin when I said that. So I would suggest that if if I reject the constraint thesis, so does Jack. And I would say you would be in the problematic position of defining originalism in a way that excludes Jack Balkin, because he rejects the constraint thesis. And I doubt you would want to be in that position. You said it would be weird if a statement of originalism excluded its canonical proponents. So I'm going to have to go back and look at my language. When I said it's not a constraint, I didn't mean, I wasn't using it in your technical sense of a constraint thesis, okay? And when I tried to think about amending constructions in our constitutional practice, constructions that are somehow incompatible with the text, I can't think of any that I support. And the only two examples I could think of would be the common originalist view that the 11th Amendment embodies a general principle of sovereign immunity rather than a more particular provision. I think that is an amending construction that's inconsistent with the text. And the only other example I could think of was Heller's. Heller is an amending construction of the constitutional text of the Second Amendment. By reading the Second Amendment as prohibiting an individual right to bear arms for self-defense that has nothing to do with bearing arms in a state militia. But I myself have never argued for anything you call an amending construction. Everything I argue for, I claim is consistent with fidelity to the Constitution as written. And I think the Constitution as written includes the small c Constitution, because the Constitution as written commits us to a scheme of abstract principles, and B, it commits us to a scheme that furthers the ends of the preamble. So I'm in no way going outside the big C Constitution and saying that. Okay.
So can I just say a couple of words? I think this does illustrate why I so much regret writing this book. Jim is totally fair to write a chapter that represents me by this book, right? But I really don't recognize myself in your chapter. That's just the honest truth, Jim. And it's because it's really because the book was aimed at students, and I'll never make this mistake again. So when I talk about the constraint principle, what's important for the purposes of understanding our disagreement is that my understanding of constraint is constraint by communicative content. Communicative content, as I understand it, right, is the contextually enriched semantic content of the words and phrases as they are combined by syntax. Right, so that has two elements. The first element is semantic content, the conventional semantic meaning of the words and phrases, right? And contextual enrichment, phenomenon such as implicature, impliciture, presupposition, and contextual disambiguation, right? So it's the content that was communicated by the text, right? The stuff that was said in the text is another way of putting it. It is not the abstract principles that the text could be said to serve or that motivated the adoption of the text that are, in some sense, the function that the text was intended to serve. That is not the communicative content of the text. The purpose for which the communicative content was uttered is a different thing than the content that was communicated. Now, that may be our disagreement, right? We may disagree right there, right? So when I say, but I believe that originalists, what originalists are after, right, and we probably shouldn't spend a lot of time on Balkan exposition. You know, I'll have my passages, you'll have your passages. But I believe that putting Balkan aside, what originalists are best understood as doing is as saying that it is the communicative content that is binding. So let me give you an example. This is an example that troubles me because it can lead to results I'm not particularly happy with. Many originalists believe that the Equal Protection Clause was radically distorted as the result of a whole series of changes to the original meaning of the Constitution made by the Supreme Court during the Reconstruction period. They wrote out the Privileges or Immunities Clause, which was the clause that was intended to guarantee basic equal rights. And then that put a lot of pressure on the remaining two clauses when the politics had changed a little bit at a subsequent period, the Due Process Clause and the Equal Protection Clause. Early drafts of the Equal Protection Clause do not include the word equal. As originally written and in several drafts, it was the Protection of the Laws Clause. And its primary function was to ensure that the state would protect the property rights, liberty rights, personal security rights of the former slaves, right? So that a government, and it's all about enforcement of the law, right? A government cannot say, we're going to protect the property rights of white citizens, but not the property rights of the former slaves. The government cannot say, we will protect white citizens against violence, but we will not protect the former slaves, right? That interpretation of the Equal Protection Clause is lost. But if that interpretation of the Equal Protection Clause is restored, the Equal Protection Clause is not a general charter for equality. It does not, by the content communicated by its words, say anything about general laws that treat people differently on the basis of their gender, their racial status, etc. It's about the protection of the laws. There was a different provision that was designed to serve this purpose of making sure that people have equal fundamental rights. That was the Privileges or Immunities Clause. The Supreme Court wrote that out of the Constitution in a series of decisions, Slaughterhouse and Cruikshank, right? So now, if you do accept the constraint principle and arguendo, you accept that the Equal Protection Clause is originally communicated, this idea of protection of the laws, right, then you should reject most of the Supreme Court's modern equal protection jurisprudence, if you were convinced. I'm not asking you if you reject my historical theory of the meaning. I'm asking you the question, if you were convinced that this theory of the communicative content of the clause was correct, would you then disavow modern Equal Protection Clause doctrine, or the idealized version of it that you think is best supported by a moral reading of the idea an equality clause.
Well, I would not have accepted that as the constraint or the character of the language or the character. I would not have accepted that characterization of the character of the commitment or the character of the constraint. So I wouldn't be put in the position of saying, oh, we've got to adopt an amending construction to get our modern understanding of it.
Why don't you ask him if the court?
What did you ask?
No, I want to ask him. I want to ask him a different question. Why don't you ask Jim that same question by altering the context a little bit? In other words, why don't you ask Jim the same question, saying that if the court had not destroyed the Privileges and Immunities Clause, then would Jim accept the court's doctrine on the court's evolving doctrine under the Equal Protection Clause? You've asked him an unfair question. Now, let me ask you an unfair question. You know, I honestly think the interpretive debate ended years ago. And I think its continuation has to be explained in terms of hidden agendas. And I honestly think that these agendas are hidden even from the people who participate in the debate. By your definition of originalism, then Dworkin was an originalist. If we accept the two principles as definitive, the principle of fixation and the principle of constraint, let's consider Dworkin's classic thought experiment regarding the father instructing his children to be fair to people. The idea, or the word fairness, refers to a concept, a general concept. That general concept invites competing conceptions, and a process takes place, a process ensues, a process of back and forth between these competing conceptions. But the concept remains fixed throughout this process. The concept, the general concept of fairness doesn't change. Not only that, the general concept exerts a constraining influence on the process of back and forth. It exerts a constraining influence in two ways. Number one, it inspires a sense of fallibility among the actors, and number two, it demands a back and forth in an attempt to get it right. So by these criteria, fixation and constraint, Dworkin was an originalist, and that serves Jim's general point, that originalists, for some reason or reasons hidden from view, originalists have defined their position so broadly that it has lost its cutting edge.
I don't know what to say about hidden agendas. I just don't. I think it's not helpful to talk about hidden agendas, right? Especially if you don't specify what they are.
Well, I'd be happy to specify.
So let me talk instead, and you'd be welcome to do that at a subsequent point. But let me talk about Dworkin. I want to make 2 points. The first point is a textual point about Dworkin, right? So I'm going to this is from page 21 of my paper. For those of you who have the paper, Dworkin in this passage is writing about Tribe, right? And Tribe has said that text has primacy and must be deemed the ultimate point of departure, and nothing irreconcilable with the text can be properly considered part of the Constitution. Right, so that's a version of the constraint principle, and here's what Dworkin says. That is a stronger statement of textual fidelity than I, Dworkin, would myself endorse, because, as I said, precedent and practice over time can supersede even so basic a piece of interpretive data as the Constitution's text, where no way of reconciling them all in an overall constructive interpretation can be found. Right? Dworkin was a master formulating his provisions, right, in language that sounded intuitively plausible. But right at this moment, he felt it was necessary to be clear that the text can be overwritten because his method of interpretation, his theory interpretivism, constructive interpretation, a specific theory of interpretation, has as its object our whole set of practices, which means that if the best interpretations of our constitutional practice as a whole require overriding the text, then that is what is required by law's integrity. Point number 2, the concept-conception distinction. So Dworkin takes this distinction from Rawls, who in turn got it from Galli in a very famous article in the 1950s, Essentially Contested Concepts. Right? The motivation for Galli's argument was the following phenomenon. People are discussing some piece of moral terminology, the word good, the word right, the word justice. But they seem to have different criteria for the application of these words. So the utilitarian says good, let's say it's a Benthamite utilitarian, that means the greatest balance of pleasures over pains. This is a good policy because it led to more pleasures over pains than the alternative options. And the Kantian has a different and incompatible set of criteria for understanding what the word good means. Normally in the philosophy of language, we would say they are using two different concepts because they have two different set of criteria for the applications of the concept. Galli says some concepts are not like that. Some concepts are essentially contested, right? People disagree about the criteria for application of the concept. They have different conceptions of the same concept. In Dworkin's debate with Scalia, right, and I have a very troubled relationship with both of these men, great admirers of some things they've said and done, and other things severely disturb them. But I will say this, of those two, Dworkin is by far the better theoretical debater. It's a David and Goliath situation, right? So Dworkin said, Scalia, you have made a fundamental mistake. You believe in original meaning. The original meaning of the Equal Protection Clause is the general concept of equality. The original meaning of the Cruel and Unusual Punishment Clause is the general concept of cruelty. There are different conceptions of this. You want to commit us not to the language of the text. You want to commit us to the framers' application beliefs about what is cruel or what is equal, right? Mark Greenberg has the best terminology for this. It was later adopted by Jack Balkin. This is original expected applications. Original expectations about how a text will be applied are not the meaning of the text. There's something quite different conceptually. And in the debate, Scalia grows increasingly frustrated because he knows that what he means is not original expected applications, but he cannot explain what he does mean. And so Dworkin just trounces him, right? It's sort of awful to witness, right? Because here you have Ronald Dworkin, the master theoretician, and really one of the most able debaters of theory that there has ever been. And then Antonin Scalia, no slouch, but not his match, just cannot figure out how to get out of the dilemma. There's an excluded middle problem here, right? There are not just two possibilities. either the text refers to the general concept of equality or of cruelty, or it refers to application beliefs. And in fact, the middle ground is built into Galley's analysis of what is going on here, right? When you use a word that might or might not be an essentially contested concept word, there's a lot of discussion about whether Galley is actually right about any of this. But when you use such a word, you might be using it, especially in theoretical discourse, to refer to the general concept with no content, no criteria for application. But that is not the usual way that we use general concept words. We almost always use general concept words in the sense of a particular conception. There's a very good reason for that. If you use a general concept word in its concept, in its contested concept sense, there are no criteria for its application, and therefore a statement like X is good, X is right, X is just, right, has very, very limited content. Normally, when we use these words, we use them in the sense that is specified by a general concept, a specific conception of the concept. So when we use the word equality, we have a conception of equality in mind. When we use the word right, or use the word good, or use the word cruel, we have a particular conception in mind. It is an empirical question, a question that can only be answered by history, not by armchair speculation or mere assertion, whether the language in the Constitution was used in a general concept sense. And with respect to some of the provisions of the Constitution that are sometimes asserted to be general concept words, right? I'm not sure that the whole phrasing context can plausibly be interpreted as referring to a general concept word at all. So as far as I'm concerned, this is important, right? But I don't think that Dworkin is accepting the constraint principle, and I don't think he's right about concepts and conceptions.
One more point. You have just shifted your ground. You have just shifted your ground. Your original account of the fixation principle referred to semantic meaning, the communicative content, and you referred to semantic meaning. Now you have switched to use meaning. You know that these are different ideas. Use meaning and semantic meaning are different ideas. Now, which one is it? If you go to use meaning, yes, you can reject the conception distinction. But if you go to semantic meaning, you cannot.
Well, it's not a brief question. It's not a brief question. So, no, that's not correct. The semantics of a word like good are being given an account by Galley. His account is, just to put this in a very precise way, right? So there is a very thin semantics, right? And then there are different senses of these words. One particular sense of a contested concept word is its concept sense, right? A theoretical sense which Galley is pointing us to. But these words are used in other senses, right? They are used in other senses. When a utilitarian uses the word good in its technical philosophical sense, it refers to a particular conception of good. Which sense of the word a particular writer or author is employing on a particular occasion can only be determined by looking at the communication and figuring out from the context, this is contextual disambiguation, which sense is referred to. So this is entirely consistent with the way Galley sees it, and Dworkin asserts that the framers intended to use these general concepts, words, in their concept sense and not in any particular conception, but that is an assertion not demonstrated by consideration of the context, by evidence about what content they were conveying at the time.
Yes, yes.
This work?
Yes. And then take the
Okay. So I am not a legal philosopher. In fact, this reminded me of the closest I've come to that, which is the course with Michael Perry I took in law school, which was a long time ago. So I'm going to ask my question first and approach this from a different level. The first question, and it's one we asked back in that class, is how would you distinguish, or do you distinguish, constitutional interpretation, the interpretation of the constitutional text, from something like where you seem to have arrived at, which is that's just a case of interpreting a text like patent or a patent law or something like that? Do you make any distinction amongst different types of texts, and is the Constitution distinct? But I want to pull back from, that's my question, but I want to pull back a bit and say this is a very interesting discussion, because it seems to suggest that originalism has reached a new stage, which is returning to the very sophisticated hermeneutical debates. And for that reason, I kind of see you as originalism was not that type of, it had never been there before. So in some sense, you are pushing it to a new level, but I can see why you'd be embarrassed by the earlier book, because what you're doing is you're being the Derrida of originalism, and insisting upon the essential nature, and maybe this, to the extent that Jim engaged with your earlier book, he's talking about the Constitution maybe in a more shallow way, but the Constitution that's linked to a particular politics in the history of the United States. It's Republican Party, it's Democratic Party, it's Progressive Movement, the Supreme Court. And you're really engaged with the literature of Gadamer and Barthes and Derrida, and it really has no connection necessarily to that politics. And in one sense, that's fine, right? But the earlier book was engaged with that politics. So if you've removed yourself from that, it does show that on one hand, to put it, not that everyone's an originalist, on one hand, originalism is very, very sophisticated now, but that sophistication is detached from the actual political debates about originalism in terms of constitutional interpretation as we care about it in American politics. So I want to...
So my answer to both questions starts with the interpretation-construction distinction, right? So interpretation is figuring out the communicative content of the text or oral communication, whatever it is, right? And so that enterprise is very similar for constitutions and statutes and patents. There are differences because these are different contexts. And the communicative content of text is not just a function of the semantics, right? It's also a function of implicature, right? Impliciture, presupposition, contextual disambiguation. All of those things are context-specific, and therefore the way that we look at the contextual enrichment of the Constitution may be very different than the way we look at the contextual enrichment of an oral contract, right? But the goal is the same. Okay, so construction may be quite different, right? For a variety of reasons, we tend to think of constitutions as at the top of the hierarchy of authoritative legal materials. Contracts are not. They can be overridden by statutes, by common law, right? So the process of construction may have to adjust the communicative content of the text to a set of mandatory rules. It may supplement that content by a set of default rules, right? So that's very different. So I just want to say that the theoretical work precedes the popular book, right? Semantic originalism comes before the popular book. This is like in the popular book contains some of the ideas of semantic originalism, but in a simplified form. So, yes, on the interpretation side, right, the kind of originalism that I argue for becomes very theoretical. I just don't want to be called the Derrida of anything. It will give me nightmares. But I do aspire, right, to sort of theoretical rigor informed by the best philosophy of language and theoretical linguistics that I can acquire in that part of the project. When you come to construction, we're talking about a different set of topics that are normative, right? These are normative topics. We figured out what the constitutional text, now what do we do about it? If you're an originalist, you say, well, we can only do things that are consistent with the text. If you're a non-originalist, you think we can do some things that are inconsistent with the communicative content of the text. Some originalists have an even more rigorous requirement. Everything we do must somehow come out of the text in the right sort of way, right? The only way to argue about that is to argue normatively. Now, there's another way that we can look at all of these same issues concerning construction. We can look at them positively, right? And we can ask, where are the ideological origins? What are the motivations of the actors? How does this interact with our political culture? Those are important questions, very, very important questions, not my questions. From my point of view, we ought to be doing the best moral and political theory we can as theorists to try to justify our position. So I would aspire to provide the best justification in moral and political philosophy for the constraint principle, for my version of the constraint principle, right? But if I were a non-originalist, I would be trying to do the opposite of that. I would be trying to provide the best moral or political justification for rejecting the constraint principle. That ought to be held in the realm of theory, not in the realm of positive discussions of the role of ideology and causal forces. The standards ought to be those of the best normative legal theory, which is just a species of moral and political philosophy.
I sort of have two very different questions. They both revolve around the fixation thesis. And the one I'm going to ask first was the one I was committed to, but you've said so many things that provoke the second. I think I have to mention it. The first is, in a certain way, sort of abstract, and it goes like this. You present us the fixation theory as resting on very antiseptic, sort of in some fundamental way neutral grounds. Fundamentally, you invoke an elaborate philosophy of language, linguistics, and you give us, small pieces of it. Some people here may be very sophisticated in it, but terms that scientific terms like implicature and so on. So there's that. And then the second thing is, you, in support of the fixation thesis, is you say it's just the case that these are two different functions, that people should recognize that sometimes they have the job of giving meaning to the document, and then this other stuff. And that's all you need to know that the fixation thesis is strong, or something like a pretty minimal set of arguments. My abstract concern is that given the constraint thesis, and given its great variety of constraint thesis, I'm not sure that anyone can plausibly sign on for the fixation thesis, without understanding its implications. So that now, if it's the case, for example, that there's only one way to give meaning to the text, and that is public meaning fixed at the time of its enactment, then the fixation thesis looks very good. But there might be others, and whether that's the one would adopt strikes me as hard to decide without knowing its implications. And its implications range from constraint thesis yes or no, to constraint thesis consistency, to constraint thesis all you got is what there is. So I'm not sure you can make the argument in that simple, antiseptic, almost scientific way, because its implications are everything. That's a kind of abstract objection. Then I must say, Larry, as you talk about the fixation thesis with regard to the Equal Protection Clause, my head began to swim. And there are several interesting things that came out of it. I think it's very useful. The first is, suddenly there was history, which I thought you renounced. So the fact that there used to be the word equal missing, and now it's there, suddenly that's relevant. It's all about protection. Well, surely not, if public meaning of equal is the public meaning of equal. But secondly, and I wondered about this as I read your very interesting work, and I think you're smart and interesting and impressive in all this, but I kept wondering about context and what it's doing. And the more you talk, the more context does. And the more context does, even if it is subdivided into the various tools of disambiguation, I want you to see you have an able student here, those tools are potentially extremely broad. And after all, the context here is the Constitution and constitutional practice. The context here is the 14th Amendment enacted in the time of the wake of the Civil War, intended to turn upside down this ugly history of slavery, and including the fact that there is this other provision which gets somewhat suppressed, privileges and immunities. What does context, how much can context take on here, strikes me as very important, and may be where a great deal comes to rest. So that, and finally, I must say, thinking about the question, does the Equal Protection Clause have a concept of equality embedded in it? I'm not sure I understand the theoretical reference to essentially contested concepts in Galley's way. We could talk about that, but it struck me as sort of the invocation of authority where there needed to be an argument. I don't see what disqualifies Dworkin's interpretation of the Equal Protection Clause, given everything else I've said. So I'm sorry that the first question was the one I wanted to ask all along, but everything you said about the Equal Protection Clause struck me as more and more provocative, more and more interesting about what a full reading would consist of given context, and less persuasive that you were abiding by your own protocol with things like reference to the drafting of the Equal Protection Clause.
Yeah, so thank you. All really good questions. So just a little bit on the first thing. So this paper doesn't purport to argue for the fixation thesis. I find myself saying things like this all the time. I always have to apologize. So there is a 35,000-word paper called The Fixation Thesis, right, that's unpublished, just submitted, just right now. Right now I'm going through that awful business with law reviews and expediting and all that stuff.
Something like the fixation thesis is very important. You're fixing those words.
Right.
And they
So,
want to change them.
you know, it has to be argued for, and there's no argument on offer in this paper. Has to be argued for, and all of the possible counter-arguments have to be considered, and, you know, that's why it's a 35,000-page paper. And I feel like we would just be getting off track if I started down that route now. Second thing I would like to say is just, so I don't have an official view about the meaning of the Equal Protection of the Laws Clause, right? I haven't done the historical work. I was using it as a hypothetical example, right, with Jim. And the only point of noting that the word equal was left out is to generate some intuition that, hey, maybe protection of the laws was important in some way in the meaning of this clause, right? If they added the word equal, right? I'm just trying to loosen up my audience, right? The word equal has to be taken into account, and it's got to be doing some work, and I don't really have a theory of what work it is necessarily doing there. I just don't, right? My point was a different one, which is simply that the clause was about protection of the laws. It was not a clause that said, no state shall pass any law that denies the fundamental equality of persons, right? That clause would be very suitable to sort of the Dworkinian approach to interpretation of the Equal Protection Clause. And so nothing about what I said forecloses the possibility that the word equal is a general concept word there. And I haven't foreclosed that possibility. I've simply said it must be responsive to evidence. Final thing.
I'm sorry to interrupt, but what kind of evidence? I mean, is the drafting evidence, is the Civil War evidence, or is it just intratextual evidence?
So speaking now as a sectarian originalist and not an ecumenical originalist, my theory, right? So my theory is a public meaning theory. That means that contextual enrichment needs to be responsive to the communicative situation of constitutional communication. And my view is that the Constitution was addressed to the public. The amendments are addressed to the public. That's part of the communicative situation. That's contestable. That has to be argued for. Accepting that premise, that tells you something about contextual enrichment, right? It tells you that contextual enrichment, contextual disambiguation, implicatures, implicitures, presuppositions have to be those that can be derived from the public context of constitutional communication. So the secret drafting history, right, Paulson's wonderful phrase, the secret drafting history is not directly relevant. Sometimes secret drafting history can be used to shed light on the public context. It can be evidence relevant to what the public context was, but it is not part of the public context. So all contextual, from my point of view, all contextual enrichment has to come out of the public context. Intentionalists of the sort of modern Gricean sort, they have a different view. They would say it's the author of the text that counts, right? And, so then you'd have to figure out what context they were writing in. Yeah, but from my sectarian view, it's the public context. And so you have to ask, in the public context, was there an implicature here, right? You could make an argument for Jim's position that would be an implicature style argument. They didn't say anything about the anti-caste principle, but in the public context, the text of the 14th Amendment creates an implicature that there is an anti-caste principle, right? That's what was in fact communicated. That would be, in my view, if that argument were made successfully, that would be part of the communicative content of the constitutional text. For various reasons, I think it's unlikely that the anti-caste principle was seen as, would qualify as an implicature, right? We'd have to argue that out based on the history. But if it were, if you made the right kind of argument, and if I were convinced, then I would say, yes, anti-caste principle, didn't realize that before, but now I see that was in the communicative content.
Okay, one more question, and I would appreciate if you could both keep it short.
Yeah, we're really running late, and we
Because
need
we are
to get
very-
connected with Fallon at 1, so we are already behind schedule. But so if it is really necessary to question now, and
But very short and the
Very short and
replies too, please.
sorry.
In the last 10 years, I have been doing the job of studying the history of constitutional debates in the Americas, particularly in Latin America. But one thing I see, I mean, everywhere in Latin America clearly, is that the constitutional conventions were basically pluralistic bodies, and that plurality reflected the plurality that was outside. And so I would say in all cases in the Americas, you have, when you say freedom of expression, well, first, within the Constitutional Convention and outside the Constitutional Convention, those who were for the religion view, I mean, they assumed that the freedom of expression did not imply a blasphemy or did not protect blasphemy or things like that. And the others, people assume that, no, this shouldn't be read as a religious thing. Or the word privacy. So I mean, you could go all and all, every question, every word, you would find the same disagreements. So they agree on having these words, but having the idea that they imply different things. And that's always, and that's not because they were bad constitutional makers, but because that reflected the only possible agreement they could make. So in a way, I don't see, I mean, working and taking history seriously, I don't see a way out of that. I mean, that every word you choose, every important concept you choose, you will always find this basic disagreement that is reflected in the Constitutional Convention and outside the Constitutional Convention at the time. So I don't see, I mean, that there is a clear fixation, I mean, camp. Things like that.
No, so I just don't disagree with the possibility that particular provisions of the United States Constitution could, in fact, right, be highly open-textured, right? That's possible, creating a large construction zone. That could be true independently of the concept-conception distinction. What I'm saying is that it has to be responsive to the evidence. So if the evidence is they couldn't agree on what privacy was, and so they just wrote a very open-textured provision, or, you know, a deeply ambiguous provision, then so be it. That's the original meaning. That creates a construction zone, right? I don't disagree that that's a possibility. Whether or not it happened in any particular case has to be responsive to the evidence.
Please join me in thanking